5 looks at the difference between direct and circumstantial evidence. Direct evidence is personal knowledge gained from observation. There's no need for you to make an inference or to presume facts in question. This is always admissible legally if obtained legally and is not a result of privilege. Circumstantial evidence asks you to take some facts that have been presented to you and indirectly prove another fact. This is also admissible so long as it is relevant. Remember that judges determine matters of law, and are the trier of law, while the jury is the trier of fact. They're going to determine the weight of the evidence, which includes how credible the witnesses are and how credible the evidence is. It is up to the trier of fact, the jury, or in case of a bench trial, the judge, to decide the proper importance of any piece of evidence. If the trial has a jury, the jury decides this issue, and if it's a bench trial, only the judge decides this. Often the credibility of the witness is what is most important. In terms of circumstantial evidence, basic questions for a jury include: did the defendant have the skill and technical knowledge to commit the crime? Did the defendant have the means to commit the crime, the physical capacity to do so, and the required mental capacity? All of these questions point to the defendant's ability to commit the crime. Circumstantial evidence is also going to look at intent. I'm going to look at several things here. One is the motive, which is the rational, emotional, or practical reason for committing an act. And while generally you don't have to prove motive in order to find someone guilty, most jurors want to know why somebody committed a crime. Modus operandi is defined as a similar pattern of behavior or plan. So oftentimes we're looking at past crimes here, and that the pattern or behavior or the method by which they're committed mirrors the present offense. This is often used to show that an act is not an accident. You may also look at threats to infer intent. This is a statement or promise made in the past to commit an act that's similar to the present crime. In terms of guilt, behavior after the commission of a crime is generally admissible. For example, the suspect tried to avoid capture or punishment. The suspect concealed evidence. The suspect was in possession of stolen property or was suddenly wealthy. And the suspect threatened a witness to the crime. Some Fifth Amendment issues come into play here. Silence before or after the crime cannot be admitted as evidence of guilt. In Griffin v. California from 1965, the defendant, Edward Griffin, was accused of murder. At trial, he did not take the stand to testify in his own defense. The prosecution commented on his silence, stating that it was evidence of guilt, and Griffin was then sentenced to death. On appeal, the Supreme Court ruled that the prosecutor's comments were improper and ordered a new trial. So you cannot say in court that perhaps the reason the defendant did not take the stand is because he or she is guilty. You might also admit some testimony or some evidence related to someone's character. Character is defined as a person's moral traits, while reputation is defined as what people believe to be a person's character. Usually character is only an issue if the defendant raises it as a defense. So if the defendant raises it as part of their defense, then the prosecution is allowed to address character. Otherwise, they're usually not. It can be limited to whether a defendant did or did not commit a specific act. Character of the victim can be critical and is admissible in cases of self-defense. So the defendant's character has to be raised by the defense itself, and cross-examination is critical here. Specific character traits are often raised relating to acts of violence or honesty to show that the person has acted in conformity with that trait. This can be raised by the defense or the prosecution. Character of the victim can be raised by either side and is often related to violence or truthfulness. Other acts evidence. This is admissible under Federal Rules of Evidence 404, Section 6. The prosecution frequently seeks to admit past crimes committed by the defendant, and the general rule is that past crimes are not admissible, but they may be admissible if they can show motive, opportunity, planned preparation, knowledge, identity, or absence of mistake. And this is usually a major issue of dispute at trial between both the defense and the prosecution. Of course, the prosecution wants to admit as many prior bad acts as possible, and the defense wants to limit those altogether. Past acts evidence could be used to show identity, that someone is admitted to. It could be admitted to show that past crimes are part of the current pattern, that modus operandi, and this seeks to identify the current crime with past crimes. They might be used more commonly to show habit or custom. It's often used to show behavior. The evidence is admitted to show that they acted or did not act in conformity with past behavior. Past acts evidence can also be used to show that the past act is similar to a current crime, thus showing it was not an accident. And opposing sides usually use it to discredit a witness. It has the greatest impact if the past act was fraud or perjury, basically arguing that there are prior false claims that have been made. Juries are also not told of any plea bargains, whether or not someone was offered an opportunity to plead guilty, or whether or not they sought an opportunity to plead guilty. And the rationale here is that parties need negotiations to be secret. If they weren't secret, many parties would hesitate to negotiate. The content of the discussion could be admissible in rare cases if subsequently one party changes testimony, and then you could basically argue that they're perjuring themselves, or if one side fails to follow through on terms of a plea bargain. Circumstantial evidence regarding the victim is typically offered to prove the actual crime occurred. Evidence can be used to show an accident or absence of an accident. Behavior of the victim might also be introduced to show not all victims are alike. This victim's reaction to a crime and situation vary dramatically, and behavior can be observed before, during, and after the crime. Any of that behavior can be admissible. Victims of crime may also suffer psychological impacts, and some of those possible symptoms and illnesses include variations of post-traumatic stress disorder, rape trauma syndrome, battered women syndrome, and then, of course, just post-traumatic stress syndrome as well. In the past, rape victim sexual behavior was often examined in open court, but today we have rape shield laws that do not allow that information to be admitted. Because it was allowed in the past, victims hesitated to come forward with accusations of rape. Gradually, all states placed limits on what questions could be asked of a rape victim. At the federal level, Federal Rule of Evidence 412 is the federal rape shield law. It makes the sexual history of the victim generally inadmissible, with a few exceptions. Evidence that another party committed the rape, evidence of consent to the sexual act, and evidence which, if excluded, would violate the defendant's constitutional rights. That is the end of Chapter 5.